Hello friends, I hope all of you are doing well. I am CMA Sridhar Akhula and I welcome you all to Finance MCQ channel, a channel where we are covering your technical syllabus, that is paper 2 of general syllabus. So friends, in the previous lecture we studied the provisions related to public issue of shares and prospectus, and today we will study provisions related to private placement as covered under Companies Act 2013 of your technical syllabus. Friends, this technical syllabus includes subjects such as costing, then commerce and accountancy, management, finance, Companies Act and economics. And friends, this technical syllabus is very important for your selection as it covers 100 marks in phase 1 and is also having 2/3 weightage in phase 2 of your SEBI grade A officer exam. So let's begin. Private placement is defined under section 42 of Companies Act 2013. So friends, private placement is a way of raising capital that involve making an offer or an invitation for sale of securities to a relatively small number of selected investors and institutions such as banks, insurance companies or pension funds, and it is other than by way of public offer through issue of private placement of a letter. Now friends, let's move on and study the procedure related to private placement. So friends, remember that the maximum number of persons to which allotment can be done in a year shall not exceed 200 excluding qualified institutional buyers. So friends, what are qualified institutional buyers? Friends, qualified institutional buyers are investors having expertise to evaluate and invest in capital market, and friends, these are given some extra privileges by SEBI under SEBI rules, and example include public financial institutions, scheduled commercial banks, foreign institutional investors or venture capital funds, and friends, even pension fund or provident fund with minimum corpus of 25 crores are also qualified institutional buyers. And friends, even employees of the company being offered securities under ESOP, that will also not be calculated within the limit of this 200. And friends, if the private placement exceeds the prescribed limit, that is 200, then in that case that shall be deemed to be an offer to the public and shall accordingly be governed with the provisions of public issue. So friends, the proposal for private placement should be previously approved by shareholders of a company by passing a special resolution in the general meeting for each of the offers or invitation. But friends, in case of non-convertible debentures, it will be sufficient if a company pass a special resolution once in a year for all the private placements to be made by the company for the non-convertible debentures during the year. While for the other class of securities, special resolution is to be passed prior to the issue of every private placement. Moving on, in the notice presented to the shareholders for approval in general meeting, the following disclosure shall be made. And friends, it should be mentioned the particulars of the offer, including date of passing of board resolution. Apart from this, the basis for justification for the price of the offer or invitation, then the name and address of the valuer who performed the valuation of securities, then apart from this, the amount which the company intends to raise by such private placement, and friends, in the end, any material terms of raising such securities, the proposed time schedule, the purposes or objects of offer or contribution being made by promoters or directors should also be mentioned in the explanatory statement annexed to the notice for shareholders for approving them in the general meeting. Moving on. So friends, as we have seen in the definition that under private placement, offer shall be made through the issue of a private placement offer letter. So friends, every identified person willing to subscribe to the private placement issue shall apply in that private placement application issued to such person along with the subscription money. And friend, this subscription money should be received by the company either by check or DD or any other banking channels and never by cash. And friends, no fresh offers or invitation under this section shall be made unless the allotments in respect of any offer or invitation made earlier have been completed, or that offer or invitation has been withdrawn or abandoned by the company. So friends, unless the previous issues have been either completed or have been abandoned by the company can never issue a fresh offer of invitation for private placement. And friends, like in case of public issue, the money received on application under this section shall be kept in a separate bank account in a scheduled bank, and the money shall not be utilized for any other purpose other than for adjustment against allotment of securities or for refunding of the money in case the company is unable to allot the securities. Moving on. So friends, a company making an offer or invitation under this section shall allot its securities within 60 days from the date of receipt of the application money for such securities. And friends, if the company is not able to allot the securities within that period, then it will have to refund the application money within 15 days. And friends, if the company is not able to refund the amount within 15 days, then it will be liable to repay the money with the penal interest of 12% after the expiry of 60th day. So friends, this slide is very important as MCQ can be easily framed on the basis of this topic. So remember that when a company is making a private placement, it has to allot its securities within 60 days. And friends, if it is not able to do that, it will have to refund it within 15 days. And the company, if it is not refunding the amount within 15 days, then a penal interest of 12% is leviable. And friends, remember that in case of public issue, this penal interest was how much? It was 15%. And friends, in that case, the time limit for allotment of securities was 30 days. So friends, we can see that there is a more stricter rules with reference to a public issue. Moving on. So friends, no company issuing securities under this section, that is private placement, shall release any public advertisement or utilize any media, marketing or distribution channels or agents to inform the public at large regarding such an issue. So friends, since here securities are issued in a private placement mode to some selected group of target investors, so informing the public at large will not serve any purpose, and even that is also not allowed under this section. Moving on, friends, the company making an allotment of securities under this section shall file with the registrar a return of allotment within 15 days from the date of allotment in such a manner as may be prescribed, including the complete list of all the allottees, their full names, addresses, number of securities offered, and such other relevant information as may be prescribed. And friends, the provision of filing return of allotment of securities with the registrar within 15 days shall not be applicable to NBFCs, that is non-banking financial companies registered under RBI under the RBI Act 1934, and even in case for housing finance companies which are registered with the National Housing Bank under the National Housing Bank Act 1987. So friends, as we have seen in the first lecture itself, that whenever an organization is governed by any special act, the supremacy will always be of that special act. So friends, remember that the company shall not utilize the monies raised through private placement unless the allotment is made and the return of allotment is filed with the registrar in accordance with the subsection given in this act. And friends, as far as the penal provisions is considered, if a company defaults in filing the return of allotment within the period prescribed, that is 15 days, so the company, its promoters, its directors shall be liable to a penalty for each default of 1000 rupees for each day during which the default continues, but not exceeding 25 lakh rupees. And friends, if the company makes an offer or accept monies in contravention of this section, the company, its promoters and directors shall be liable for a penalty which may be extended to the amount raised through the private placement or 2 crore rupees, whichever is lower. So friends, and the company will also have to refund all the monies and interest to the subscribers within a period of 30 days of the order of imposing the penalty. So friends, if we could summarize these penal provisions, so first one was default in filing of return of allotment within 15 days with the registrar. So friends, here the penal provision would be the lower of 1000 rupees for each day or 25 lakh rupees, whichever is lower. And friends, if the company makes an offer or accepts or monies in contravention with the provision of this section, the penal provision would be lower of the amount raised through the private placement or 2 crore rupees, whichever is lower. So friends, with this we finished the provisions related to the allotment of securities by private placement. Friends, for more practice of MCQs on this topic, please visit financemcq.in, where the entire SEBI grade exam technical syllabus is covered in MCQ format. Friends, here 2000 plus subject wise, topic wise MCQ questions are presented for you to practice. Friends, explanation are also added for correct answers wherever required. So friends, apart from this, there are 25 test series covering the technical syllabus for more and more practice. So friends, do visit financemcq.in and practice your technical syllabus well. And friends, don't forget that this technical syllabus is having 100 marks in phase 1 and is also having 2/3 weightage in phase 2 of your SEBI grade exam. So friends, this technical syllabus is very important for your selection. So friends, that's all for today. We will go through some more insight into the topic tomorrow. Till then, thank you very much for watching. Take care and goodbye. And don't forget to like, share and subscribe.